This video covers Wisconsin versus Yoder, a landmark 1972 Supreme Court case concerning religious freedom and compulsory education. The case began in 1968 when 3 Amish fathers were criminally prosecuted for refusing to send their children to public high school past the 8th grade, citing religious beliefs incompatible with a high school education. The state of Wisconsin presented 4 core arguments. They claimed the compulsory school law was a neutral exercise of police power necessary to prepare citizens for modern society and protect the welfare of children. They also claimed no less intrusive means were available. The Amish, led by Yoder, countered with 4 arguments. They invoked the Free Exercise Clause of the First Amendment and parental rights. They asserted their existing educational system was adequate and that the state had not chosen the least restrictive means. The factual background centers on the conflict between Wisconsin's law requiring school attendance until age 16 and the old order Amish tradition of ending formal schooling after 8th grade for religious reasons. The families argued this threatened their community's survival. The procedural posture saw the fathers found guilty in Greene County Court and fined. This was affirmed by the Circuit Court, but then reversed by the Wisconsin Supreme Court, leading the state of Wisconsin to appeal to the U.S. Supreme Court. The central constitutional question was whether Wisconsin's compulsory education law violated the Amish's rights under the First Amendment's Free Exercise Clause. The court had to weigh the state's interest in education against fundamental religious liberty. This mock trial focuses on the Yoder defense and the powerful claims they made for religious autonomy. The Amish fathers claimed their fundamental free exercise rights were violated. They argued that compulsory education threatened core Amish values, asserting religious freedom should supersede the state's interest in mandatory schooling. The defense used expert testimony to support their claims. Dr. Hostetler and John Stoltzfus confirmed that the Amish Society's vocational training system provided sufficient practical education for the children's way of life. Yoder, the lead plaintiff, testified that his faith dictates the community, not the individual, raises children. He affirmed that their homeschool, which includes reading, writing, arithmetic, and religious code, is sufficient for a life of honest labor and godly service. As the lead father charged, Yoder represented the conflict between faith and state law. His testimony emphasized community-led religious education and his belief that schooling past 8th grade was religiously incompatible. Miriam Yoder testified about the practical and spiritual role of the homeschool. She stated that children learn the land, the craft of building, and principles of humility, preparing them to be productive church and farm members after 8th grade. Miriam Yoder's testimony affirmed the importance of homeschooling, emphasizing that children gain essential craft skills and principles of humility, preparing them adequately for their religious and agricultural community life. Elder Jacob Kaufman, an Amish bishop, testified that the Ordnung limits formal schooling after the 8th grade. He explained that higher education introduces worldly ideas, and forcing youth into those schools would be a direct attack on their religion. Elder Jacob Kaufman validated the sincerity of the Amish religious beliefs. He emphasized their commitment to a self-sufficient community, confirming that compulsory high school attendance was a severe threat to their unique religious life. Dr. Hostetler, a sociologist, testified that Amish children achieve functional literacy, numeracy, and vocational competence beyond the state's minimal standards for a farming, non-industrial life. Their schooling is tailored to the real demands of their life, not modern citizenship. Dr. Hostetler provided expert sociological testimony, defending the unique Amish way of life. His research supported the Amish religious liberty claims by confirming their system offered sufficient vocational training. Now we examine the arguments and witnesses presented by the state of Wisconsin. Wisconsin emphasized its strong state interest in education, arguing for 2 more years of compulsory schooling. Witnesses supported the need for educated and informed citizens, seeing education as essential for future civic participation. The state defended its interest in preparing all citizens, claiming that 2 additional years of compulsory schooling were vital for civic engagement and an informed populace. Wisconsin presented expert testimony supporting its compulsory law, arguing that 2 extra years of schooling are crucial for informed citizenship and emphasizing the state's broad interest in its children's welfare. The content of this slide is not available. 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 The initial trial court in Greene County found the Amish fathers guilty, imposing a small fine, which affirmed the state's compulsory attendance law. The family subsequently appealed this conviction. The Wisconsin Supreme Court reversed the lower court's decision, siding with the Amish fathers and protecting their religious freedom. This ruling deemed the state's compulsory education law unconstitutional as applied, prompting Wisconsin to appeal to the U.S. Supreme Court. In 1972, the U.S. Supreme Court ruled in favor of the Amish, upholding their free exercise rights. The court found that compulsory high school attendance for the Amish was unconstitutional, as religious freedom outweighed the state's interest. The Supreme Court majority upheld the Amish free exercise rights, ruling compulsory high school attendance unconstitutional. They emphasized that the Amish religious belief was genuine, outweighing the state's educational interest. Justice Douglas wrote the primary dissent, arguing that the children's rights were overlooked. He stressed that children should have a voice in their education and believed the state must protect all children's future welfare. After the Amish fathers were found guilty at the Greene County Court, they immediately appealed. The conviction was affirmed by the Circuit Court, but later reversed by the Wisconsin Supreme Court.